Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Attention gun owners and others who place value in defending their constitutional rights, such as the Second Amendment right to keep and bear arms. We just handled a situation in which a person was charged with misdemeanor simple assault and summary harassment for a physical altercation with his wife. The person is a firearms enthusiast and owns a license to carry concealed firearms. No firearms were involved in the altercation, and the spouses have reconciled and wish to put this incident behind them. However, because the person was charged with a misdemeanor simple assault offense involving a domestic violence situation, the county sheriff revoked his license to carry a concealed firearm. Also, in the criminal case, a plea to summary harassment was negotiated in order to protect the person's Second Amendment right to possess firearms. However, the judge presiding, on his own volition, added the following words to the sentencing order, quote, "This offense is a crime of domestic violence for reporting purposes," end quote. No one knows why the judge added those words. In any event, those words created a real predicament for this particular individual. Was the judge attempting to characterize the summary offense as a misdemeanor crime of domestic violence, which would then make this person a prohibited possessor under federal law? Was it now illegal for this person to possess firearms? Also, was the judge attempting to characterize the summary offense as a misdemeanor crime of domestic violence so that the new law on mandatory relinquishment of firearms would be implicated, and thus this person would have to relinquish all of his firearms? Now, federal law prohibits and criminalizes the possession of firearms by those who have been convicted of an offense the Federal Gun Control Act calls a, quote, misdemeanor crime of domestic violence, end quote. The Act sets forth several elements that, if satisfied, means the underlying offense qualifies. And the Gun Control Act is complex and tricky. For example, there is one section that disqualifies or criminalizes what it refers to as felons from possessing firearms. Then in another section of the Act, it defines felons to include certain misdemeanants, those convicted of certain misdemeanors under state law. So in that case, felons can mean misdemeanants. So things in the Gun Control Act are sometimes not what they seem. In any event, it was not clear why the judge added that phrase or what the legal implications of that phrase were to the individual who wanted to protect his Second Amendment rights. The judge's actions required us to do a lot of very quick legal research and quick work on the case. In the end, we were able to reach a legal conclusion and advise our client accordingly. He kept his firearms and even had the sheriff reissue his license to carry a concealed firearm. Perhaps just as importantly, he now has the peace of mind that he is a lawful possessor and may continue to enjoy his Second Amendment rights. But this case highlights the importance of having competent firearms counsel involved in any domestic violence-related matter. If you're charged with any crime, and most particularly a crime that could be characterized as a crime of domestic violence, you're well advised to retain one of Scaringi Law's criminal defense attorneys. We are well versed in firearms law and ready, willing, and able to defend your Second Amendment rights. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.